Hi everybody, this is Module 2's video review for you, so I hope you find this information enough to supplement the reading so that you are actually understanding the things that are in the reading and not just kind of glancing over them or glossing over them and really not appreciating what the material is all about. So I always like to add a little bit of audio video as much as I can, and I'm sorry if the voice doesn't match up with the mouth. It's a little bit I don't know if the technology is just not keeping up with all of that, but I apologize for it. So anyway, Module 2, we cover Chapters 1, 4, and 5. And Chapter 1 is all about the different types of laws that we have in this country. You need to understand what we mean by sources of law. Sources of law can be either primary or secondary. The only law that's binding on a court would be primary sources of law. Those include constitutions, statutory law, and case law. So let's talk about each one of those in a little bit more detail so you have a very clear understanding of what each is about. There are, as we'll talk about in Chapter 4, we have federal and we have state governments, and in both of those we have these different types of primary sources of law. So you have constitutions not only on a federal level, that's the United States Constitution, but every state has its own constitution as well. So you kind of have to understand that we have federal primary sources of law and we have state primary sources of law, and they happen to work together side by side. Just depends on what cause of action you have and what type of law is being applied. So on the federal level, the United States Constitution is the supreme law of the land. It's the highest law that we have to look to. It is really critically important in many areas of the law, but particularly so in criminal law. As you can imagine, when we talk about the Bill of Rights, which are the first 10 amendments to the U.S. Constitution, those really have a significant bearing on criminal law would be your Fourth Amendment, your Fifth Amendment, Sixth Amendment, and Eighth Amendments. And when we talk about personal freedoms, a lot of those come to us from our First Amendment: freedom of press, association, speech, peaceably assembling, those types of things. But the U.S. Constitution is the highest law that we have. No law, federal or state, can be written or passed that's in conflict with the U.S. Constitution. The highest court that we have, as you learned last week, is the United States Supreme Court, and its whole function is to make sure that all the other courts are upholding the Constitution. State constitutions are similar. They would not have anything in the state constitution that would violate the U.S. Constitution, and state statutory law and state case law cannot be in conflict with the state constitutions either. Below that, we have statutory law. That's the second highest form of law that we have, whether it's the federal government or state. Statutes are passed by the legislative branch. The legislature sits down and decides. It takes a long time. If you've ever seen that little YouTube clip from Schoolhouse Rocks, how a bill becomes a law, that is truly, you think it's a little kids show, but it actually shows you just how difficult it is for a piece of legislation to go all the way from being a bill all the way into a statute. If you ever happen to pull up your state statutory laws, the RCWs, you can scroll down and see at the bottom of a statute, click on any single one of them, and you'll see a long list of information at the bottom, and those are all the stages that it went through in order for that bill to become that statute. When you see how long it takes, it can take years and years and years for that to happen, and a lot of cooperation and a lot of people lobbying to make that bill become a law. You really start to have an appreciation for your state statutory law in a whole different way. That's really important for you to have. So that's your second highest form of primary authority. The third type is case law. Case law, as you saw in your reading, it's built in this country on the common law heritage, which means that we derived a lot of our laws and a lot of our practices and procedures from English law because we seceded from them way back when. And we took what they had in place and we borrowed that for a period of time, and that became the common law. So in this country, we still have lots of remnants of the common law. Some of it is woven into our statutory law. Some of it comes to us from case law. But basically, common law just means rulings are based on traditions and practices of the people who live in that society. over time our society's values change. Obviously, you can see that with Brown versus Board of Education and all the types of segregation things that we had in the past. Those are not what reflects the values of society today, so that law had to change. And that's how it's just a reflection of the norms of society will always be reflected through the common law tradition, which is oftentimes embedded in our case law. So under the doctrine of judicial review, as we will talk about in just a minute in Chapter 4, courts are able to look at statutory law and are able to make sure that it is in compliance with the U.S. Constitution. But those are basically your three different types. When it comes to case law, it's important for you to understand that case law depends on a certain degree of predictability. So when courts look at issues and they make rulings, they don't want to have to look at that over and over and over again. They expect the lower courts in that jurisdiction to apply the rule that they are giving out in an appellate decision. And when that happens, if you have another case that comes before a court in that jurisdiction that has essentially the same facts and the same legal issue, it has to apply the rule of law that the higher court handed down previously. We call that prior case precedent, and when a prior court invokes precedent, they are adopting or using the doctrine of stare decisis. Stare decisis, Latin for let the decision stand, and the only way that you can get around using that prior law is to say, hey, these two cases are really different on their facts, so they're factually distinguished. Or you can say that that old case is no good anymore. I'm going to overturn that, like Brown versus Board of Education, and say we need to write new law. Our society's values have changed at this point in time. So that's Chapter 1. Chapter 2 goes into much more detail about constitutional law. It's a very big body of law. It's used for many different purposes, from analyzing criminal actions. There are lots of appeals in criminal cases, and also dealing with liberty rights and due process rights for people, because we have lots of personal freedoms and protections in place in this country, which is a wonderful thing. And the challenge to those will always be on an argument of constitutional law. That means that the law involves some question that arises under the Constitution. As I mentioned before, courts have the authority and the ability to review decisions of the legislature, so the laws and the statutes that are passed. Courts can review those under something called judicial review. And that comes to us from the very famous and old case of Marbury versus Madison. That's important for you to know. You don't really need to know much more than that. You should know, though, about judicial review and what that means, and what's the famous case that doctrine came to us from. So those two things are important for you to know. You should also know that there are 7 articles in the U.S. Constitution. And in those articles, it sets out the 3 different branches of government. We have a judicial branch, which are our courts. We have the legislative branch, and we have the executive branch. And the legislative branch will write the laws. The judicial branch will interpret those laws, particularly using judicial review. And the executive branch enforces those laws. So you really need to understand what that is. It's called the doctrine of separation of powers, when each one of the branches has their own delegated powers and responsibilities. The doctrine of checks and balances is also important for you to know and understand. Under that doctrine, each branch of government has only so much power, and no one branch is to have more power than the others. So each branch keeps the other in check. So there's never one branch that gets too powerful. Also understand the idea of federalism, which is something that I did just mention a couple of minutes ago. We have state and federal governments operating side by side. So on each side, whether it be state or federal, there is an executive branch, there's a judicial branch, and there's also a legislative branch. And that's the concept called federalism. Other than that, the only other thing from Chapter 4 that's super important for you to know is the Bill of Rights, which are the first 10 amendments to the U.S. Constitution. And again, as I mentioned before, a lot of these have a bearing in a criminal action, for example, the 4th Amendment, 5th, 6th, and 8th. And the other ones, there are a couple of the amendments that actually we don't use too much anymore. The 7th Amendment, for example, even the 2nd Amendment, the right to bear arms, or as my son has a t-shirt that says the right to arm bears. But those are the ones that, you know, they're there. They may come back up. You never know. If this country goes back into a wartime or something like that, those will definitely become more important in the future. Okay, the last chapter that you guys talked about for Module 2 is on ethics. Ethics is really a very important topic in the law in general. In business, it has another layer to it as well. You know, there are a lot of companies and corporations that really focus so much on short-term short-term or short-run profits, as opposed to looking long-term investment and making sure that they are really protecting the goodwill of the business, which is the reputation of the business. As individuals, we all have individual reputations, and we should act with integrity and honesty. But in a business environment, it's super important because sometimes the name brand will mean everything. And if companies are acting in an unethical way, that certainly will, in the long run, usually have a negative impact on profitability. But lots of times what is on many people's minds are maximizing profits in the short term. So really that is, I thought that chapter was fairly self-explanatory. If you have any questions on any of this material, please just feel free to post something under Ask the Professor or send me a message through the message board. Thank you so much, and on to Module 3.